Ladies and gentlemen, we begin our second session of this national conference now. In 2023, the Australian Monarchist League launched what we call the Philip Benwell State of the Constitution, an initiative that's dedicated to studying and defending Australia's founding document. And this year, instead of having that as a separate event, we actually thought we'd integrate it into the conference as a second panel discussion. So you'll be able to ask your questions and so on, same procedure as before. Over the last 12 months, since the last state of the Constitution, our Constitution has faced a number of questions. It's to the benefit of us all, I think, if we relive just one key moment from the opening of the 48th Parliament.
Honourable members making an affirmation. Do each of you solemnly and sincerely affirm and declare that you will be faithful and bear true allegiance to His Majesty King Charles III, his heirs and successors, according to law?
I swear allegiance to the authority.
Now, ladies and gentlemen, you might not have picked that up on the recording. It is quiet even when amplified. But when called upon to make and subscribe the Oath of Allegiance, as he is lawfully required to do by Section 42 of the Constitution, Robert Catter, the member for Kennedy, said, "No, I swear allegiance to the Australian people." So, how is it that Mr. Catter can defy the Constitution so blatantly and without reproach? And what can we do about his defiance? So, this state of the Constitution's stellar lineup answers these questions and more. But just an unfortunate note, I got a call from Senior Counsel Matthew White this morning. Unfortunately, he can't be with us. He's come down ill. But Matthew is a very eminent person, barrister. Was also Australian for Constitutional Monarchies, 1998 or 9, London correspondent during the referendum. So he's been involved in this debate for some time, and we're very grateful to have him on board, but sadly can't be here. So that leaves us with three fantastic individuals, all of whom have actually appeared in State of the Constitution before. Dr. Neville Rocco, King's Counsel, is a barrister, academic, and a member of the League's Central Committee. Morgan Begg is a lawyer and the Director of Research at the Institute of Public Affairs. And of course, Philip Benwell, member of the most excellent order of the British Empire, has served as the National Chairman of the Australian Monarchist League since 1993 and is, dare I say, Australia's most consistent and genuine defender of our Crown and Constitution. Please make this State of the Constitution panel welcome. So I think what the best way to go about this is to just start with what we call the Catter matter and address that from the perspective of, let's say, Philip, what's actually happened here? Can you give us the sort of facts of the situation?
Yes. In July, in July, when Parliament first resumed sitting after the May election, each member of Parliament and each senator are required constitutionally to swear allegiance to the King.
Closer to your mouth.
Pardon?
Just hold that.
Closer to your mouth.
Each senator and each member of Parliament are required to swear allegiance to the King. They gather around the table where the clerk, on behalf of the representative of the High Court or a judge of the High Court, will read out the oath or the affirmation, and then they say they agree. Catter is caught on the YouTube video, as you will see, saying, "No, I swear allegiance to the Australian people." Now, commendable though that may be, it is not the required oath or affirmation of allegiance to the king. And there is a reason why the allegiance to the king, or earlier the queen, should be made, because the monarch is our sovereign head of state, and the allegiance is to the king and our system of governance and the rule of law and the Australian Constitution. Qatar, by avoiding that, has no right to sit in the Parliament according to the Constitution. But the problem is, no member of Parliament is prepared to do anything about it. I have contacted many Liberal members who are monarchist, and they treat Qatar as a joke and say, oh, it's not worth doing anything, just let it go. But we will not let it go, because the next thing that could happen is, seeing that Qatar is getting away with this, we'll have the Greens members doing the same thing, then Labour members doing the same thing. You might remember Lydia Thorpe with her antics on the oath of allegiance in the Senate. But she eventually made the oath. Qatar did not.
Neville, take us through some of the language in section 42. So there's a couple of important words in there. There's the phrase, I think two that we can draw attention to, make and subscribe.
Yes.
And then also before taking the seat. Because it's important to say that, actually no, I'll let Neville say that. He's much better anyway.
Well, I think you've gone to the heart of the chase here, that the express words of the section that's, that requires the oath, section 42, is quite explicit. It says that they have to make or affirm and subscribe. The difference of opinion between what is quite apparent on the face of the Constitution, and therefore my opinion, and that of the Clerk of the House, is that the clerk is of the view that subscription is enough. That cannot be so, otherwise there would be no use for the word and. It must be a twofold staging, and that is not unusual. If you go to a solicitor to swear an affidavit, and if you go to a JP to make a statutory declaration, there will be a twofold step. The steps will be, number one, there's a writing that has what will be your defamation, and they'll ask you, do you swear, do you affirm, do you state that to be the truth? And then you'll be invited to evidence your having stated that to be the case by subscribing on the document. So it's not a trivial thing. It's not unknown for there to be the two-phase step approach to a solemn swearing or a solemn oath occasion. And it is something that needs to be emphasised, because once the oath is gone, once the oath is diminished to something that anyone can imprecate in any form they want, then we have nothing whereby loyalty and allegiance of our elected representatives is there. It's wiped away completely. Now, let me give some examples. when you go to court, before you give your evidence, you'll have to swear or affirm that what you're going to say is the truth. If you try and fiddle around with your own set of words and not take the oath or the affirmation that is provided to you before you give your oral evidence, the judge will do one of two things: either sit there and insist that you do so, or you'll be locked away for contempt. That's one example. Another example, members of the armed forces are required to make oaths of allegiance. There are certain forms that are laid out in appropriate legislative positions that say that they must swear an oath of allegiance. Now, let's say that members of the forces said, "Oh, look, I'll use my own words. I think I'll swear allegiance to, why don't we say Sudan, or I'll swear allegiance to ISIS," or something like that. The thing is, you would not want to be in a foxhole or in any contested military operation with somebody who really wasn't sworn to be on your side. The police do the same. And we could go through a host of public offices whereby it is something that we can repose confidence in because they have sworn an oath of loyalty, allegiance and service, and it is uniform across the particular service that's involved. What it also means is that these people, by swearing an oath, set themselves apart from the rest of the community. They have invoked upon themselves a duty that other people in the public don't have. If they don't take the oath, they're no different than anyone else. Now, the people who should be exemplars of this type of oath and affirmation making should be those elected representatives who are making the laws for this country. Now, it has an implication under the Constitution, and this is to what Alexander was alluding, that the provisions of Section 42 are quite clear, that until they take the oath or make an affirmation, they cannot take up their seat in Parliament. And so Katha sits in Parliament with no legitimacy, with no right to be there, and has done that really trading on the fact that people do consider him to be a joke. The place for jokes is outside the Parliament. That's where it should be. So I think that answers your question, doesn't it, Alexander?
Yeah.
Right.
It's fascinating as well to look at the language in Section 42, which is very similar, if not identical, to the Parliamentary Oaths Act 1866 of the Imperial Parliament, or the UK Parliament, which includes the phrasage make and subscribe and so on. It's almost verbatim, and in their 1901 treatise, or is it 1900, I can't remember, their annotated constitution, Quick and Garran draw attention to that Parliamentary Oath Act by way of referencing a case that occurred in the United Kingdom, and that was a matter where a parliamentarian did not correctly and lawfully make and subscribe the oath. And it's very interesting to see what happened to Charles Bradlaugh. The Parliamentary Oaths Act has a penalty built into it. You're actually required to vacate your seat as if you were dead. But Section 42 doesn't actually have that. It's clear that the Founding Fathers were influenced by this penalty, but they didn't put it into the Constitution. It's not a penal clause in the Constitution. And there's some discussion as to why that might be. In the Constitution conventions, the debates really don't cover much about Section 42. It's this sort of glossed over clause. It's taken for granted. And Philip Fish who was a Tasmanian, goes on to put it quite well. He says, "We as public men have sworn allegiance to the Crown." And that was that. It was sort of inconceivable that this could go on. So, and in Charles Bradlaugh's case, the last thing to say on this is that he was actually removed by force by the Sergeant-at-Arms. And the Sergeant-at-Arms did not permit him to re-enter the House until he was ready to lawfully make the oath. Morgan, yes, please.
Can I follow
absolutely,
up on that?
100%.
Yeah, so it's very interesting. That appears to indicate
Yeah, just hold it.
that the framers were clearly intending for legislation, for the Parliament to cover the penalties for failing to subscribe to Section 42 in legislation, as they did in so many other areas of the Constitution. And as the Parliament has actually done repeatedly, they've dropped the ball on that. So it's quite unclear what exactly happens. But I just wanted to make one comment about the Bob Catter case, which is, this has been a long time coming. For decades we have not treated oaths of allegiance seriously. We no longer ask new citizens to swear allegiance to the King. Ministers of the Crown are not required to reaffirm their loyalty to the King. We don't say it in schools. It's just not a part of the vocabulary. We've had for decades members of Parliament on both sides of the aisle who have advanced Republican ideas despite apparently being loyal to the King, which clearly they're not, and there's nothing is done about it. So, fair enough, they want to call Robert Catter a joke. Well, they're all in on the joke.
Yeah. And that's a great point from Morgan, we're grateful that he's here because he's battling some pretty bad sunburn. But that's a great point, because when Catter did the stunt that he did, the Labor the Labor front bench just all laughed. And the opposition benches, the front bench looked totally confused. There's the next part of the parliamentary video picks up Andrew Hastie and Alex Hawke and Julian Leeser being a life member of the Australian Monarchist League, just looking totally bamboozled as to what's going on. But Albanese and Richard Marles and Tony Burke and all of them are sitting there laughing. Now, I think that's what we should take very seriously in all of this, that there is a flow-on effect. So then my next question for Philip is this. What can we do about this? Even within our working group, we've got some divergent views on how you go about this. So what's your view?
Thank you. Well, we have been working on this matter basically since July. We have established a legal team, basically headed by Neville, who is a King's Counsel. We have senior counsel and other lawyers on the team, and Alexander is on that, and he has done a lot of groundwork in the matter. I have spoken with a number of members of Parliament, may I say, on both sides of the fence, and am receiving a better response from the Labour side than the Liberal side. Now, that may surprise many of you, but we go where we can to succeed, and that is what we are doing. There are various stages which take time. We are also facing obstruction from the Parliamentary Clerk's office, who have set in place a process where if a member signs the oath, that is sufficient. But that is not constitutionally correct. They have to make, that is speak, and then they have to sign the oath. So we have also looked at the legal stages that we are able to follow. we have looked at having the matter brought before the Parliamentary Privileges Committee. So there are many facets in what we have been doing, and one way or another we will succeed, because we have you behind us, and we have thousands of our supporters behind us. And we are not going to give up because, as I've said, if Qatar is allowed just to get away with this, then it sets a precedent for others to follow. And in these times, that is a dangerous precedent.
Could I just add? Could I just add this? And I think it's another issue that's often overlooked. And it is the question of integrity and honesty. I've studied a little bit about the founding fathers of the United States Constitution and their system of government that flows from it. And John Adams and others have spoke in this way, that the Constitution can only work while people are of character, integrity, and honest. So it doesn't matter what the piece of paper says, unless people are honest about how the piece of paper is to work, which is really recalling the things that John Anderson was saying this morning. Unless we have the spirit of it, then the piece of paper is worthless. And that's what the Constitution would be rendered into, just another piece of paper. So let's just explore this a little bit. The one thing that's missing, I think, in modern education is a solid knowledge of the classics, classic philosophy, classic literature, classic history. Those things are just missing, and you have to go searching for that sort of education today. It's very hard to get. But the great statesmen from centuries bygone were all great classicists, as well as versed in the law and in other aspects of social cohesion. But with particular reference to the founding fathers of the United States, each of them was profoundly influenced by the ethical constructs they'd learn by their classical reading. In other words, ethics, honesty, integrity was a part of their DNA. Now, they were human, they were flawed, there were lots of areas where they fell down, but they strove for the epitomising of that type of value. What we have today is, first of all, a lot of people in Parliament don't know any history. They certainly know no classics, and they certainly very rarely have had any sort of classical training. We can count on one hand the people in our Parliament at the moment who we would say have sufficient integrity to be entitled to the positions they occupy. If you take the entirety of the Labor Party, each one of them, as members of the Labor Party, has aligned themselves as Republicans. Now, in centuries bygone, if you swore an oath to the King, but were actively pursuing his or the Queen's overthrow, that would be treason, and your head would be on the block. Now, it's not a matter of attention at all. You can be flagrantly, without integrity and without honesty, in regard to the parliamentary oath you take. Now, if a judge took a judicial oath, then started acting according to their, contrary to their oath, Parliament would have them removed. I'll give them the other examples. But these people who have sworn, who have aligned themselves contrary to what they have sworn or affirmed, are let go by as if nothing happened. That message has to get through, that we are governed by people who are telling a lie. Now, there have been recent examples that we've seen in Senate's estimates where certain ministers have been caught out in flagrant lies. And there's a question in the press, what are going to be the consequences? Well, I put that rhetorically again. What are going to be the consequence for people who affirm or swear to an allegiance to the King, the Crown, and our constitutional way of doing things, but then want to overthrow the Crown and want to overthrow our constitutional approach, want to engage in revolution, and yet can sit there comfortably passing legislation. So I'm fairly passionate about this because I think it is just so wrong that lies can be a foundation of our way of doing business when it comes to government.
Well said.
So I suppose watch this space, as the young people say. I wouldn't know, and see where we end up. High Court has been canvassed as an option, and there are other discussions going on with senior members actually in the Labor Party, which is incredible. So, look, all good stuff there. Let's change tact a little bit, talking about integrity of institutions. We should certainly talk about, and their office holders, we should certainly talk about the dismissal in this 50th anniversary of the dismissal. Morgan, your thoughts on the dismissal in general?
I'm in favour. No, I think I'm not sure if there's any additional insight I can give to that matter. Clearly it was a crisis, a political crisis of Whitlam's own making, and fortunately the role of the Crown functioned as it ought to have, and to intervene and to resolve the crisis. So I think, and it was not unprecedented, and commentary at the time leading to the dismissal was calling on the Governor-General to actually do this. So things happened the way they ought to have. I think the one regret that you might have about the dismissal is the response in the years that followed to the dismissal. The political class, I think, was clearly rattled by the fact that the Crown had these reserve powers, and they've essentially, circled the wagons around themselves to ensure that it doesn't happen again. They've clearly established a new sort of constitutional understanding that it's wrong. They will never appoint, I think in most cases, maybe with exceptions, but I foresee that we will never see a government appoint a Governor-General who would be prepared to use reserve powers because of the acrimony that they've put around the whole event. So I think, one of the legacies of the dismissal is, we've become, the Crown itself has been much more diminished. And it's hard to see, how we get that back. So.
Well, then let's come at the dismissal from another angle. Neville, what is the Republican obsession with the dismissal?
There's a lot of mythology that has developed around the... I think, first of all, the dismissal is a misnomer, by the way. I think that the truth is that the Prime Minister had his commission withdrawn unless he would agree to certain conditions, including a general election, not being prepared to go to a general election but insisting on a half Senate election, put the Governor-General in an impossible position but to ask for his resignation effectively. So it's a constructive dismissal at the very best for those of you that have any knowledge of employment law. But I think that the truth is it was the Governor-General that was placed in an invidious position What has happened since is there's a mythology that has developed, and just to take a few examples of that mythology, it has been protested. I'll just back up a little bit and say this. I think the Republican movement derives greatly from what is called the dismissal. They thought we've got to get rid of the Crown entirely so this never happens again. So that was an impetus towards republicanism. I think that's the first thing. The second thing is that in order to justify themselves, Republicans have to say that this was unprecedented and wrong. First, they say it was unprecedented that the Liberal Party should never have blocked supply. Well, the truth is that supply had been blocked by the Labor Party when in opposition hundreds of times as a political tactic. It never brought about an election, but they were trying to bring about an election by blocking supply themselves. So there's that element of absolute hypocrisy. The second thing is they say, oh, well, it was unprecedented. No one could have predicted it, and so therefore it blindsided the government of the day. Not so. Whitlam was many things, but one has to say that he was a good lawyer, a highly intelligent man, good historian, and understood the Constitution very well, and understood reserve powers very well. And in fact, his former colleague, Doc Evatt, had written a book on the reserve powers that Whitlam no doubt would have devoured in his very, very early days. And if we want a classic precedent in Australia for its dismissal, we have the Jack Lang government back in the 30s. Jack Lang could not get supply because his government was a disaster. And the opposition was blocking that to precipitate an election. He wouldn't do it, and they had money. They had suitcases full of money running around Sydney to pay the various obligations that should have been paid as appropriations from Treasury. It was, and you had the same thing with the Kemlani loans under Whitlam. Couldn't get supply, so he's trying to arrange loans outside of the constitutional provisions and outside of Section 83. So when you peel away the elements of the mythology, the whole mystique just starts to fade, and it becomes a very routine thing that if you are governing irresponsibly, whether you've got a majority or not, but if you are governing irresponsibly, you are not adhering to the terms of the Constitution, you are insisting upon solutions that have no guarantee of success, then the umpire, being the King's representative, will step in and put an ultimatum to you. Either do X or I'll do Y. So there's nothing. When Game sacked Lang, no one said, oh, where did that come from? There's no anniversary of Lang's dismissal because it was clear there was no alternative. But because they've been able to wrap the whole thing into this mythology, and even deriving benefit from Norman Gunston having been the source of a crowd gathering, they've distorted history and then tried to use that distorted history, bereft of facts, as the justification for republicanism, and it has none, in my respectful view.
Sort of taking out the institution from within as well, isn't it? Which has been a bit of a theme of today too. A couple of audience questions coming in, which is really fantastic. I'm going to take a quick answer and go at two before I come to Philip on the dismissal. One of the audience questions I'll integrate into that as well. So we've had Chris Whittaker, one of our national councillors. Good to see you, Chris. give us a question here. Will the Australian Monarchist League seek special leave for the High Court to definitively state, so I suppose a declaration, that a new MP must make and is capitalised, affirm the oath of allegiance? I think I can say we're exploring all options. If we invade, they might just say we overacted, but that's fine. And then the next question comes from Anonymous. Here we go. According to the panel, should it be illegal for Republicans to run for and be elected to Parliament in Australia? Now, I would say, and I probably will make the assumption that the panel will agree with me, I would say no, it shouldn't be illegal, and there would be constitutional problems with that freedom, the implied freedom of association, the implied freedom of political communication. However, the shoe might actually be on the other foot. Maybe we should just stop electing Republicans. That might be a good way to go about it. And maybe we should actually, vote on that issue, which seems to, we're all of the belief is a very senior one. Okay, Philip, a question from the audience and a question from me as well. The audience question is, which I think you'd be able to deal with pretty efficiently, if Sir Paul Hasluck was Governor-General, would he have sacked Whitlam, or what would he have done differently? And my question is, as you pointed out to me over a brandy last night, you probably are one of the only people who remains who knew both Australian actors involved, who knew people who knew Kemlani, and who was also on speaking terms with Martin Charteris and Philip Moore, who are of course private secretaries to the Queen at the time. So Philip, your thoughts on the behind the scenes of the dismissal and Paul Hasluck?
If Sir Paul Hasluck was Governor-General, then Whitlam would have respected him and would not have treated him like one of his boys, like he did with Kerr. Whitlam appointed Kerr thinking he was a Labour person and would do what he wanted.
One of theirs.
He forgot or didn't take into account that Sir John Kerr was Chief Justice of New South Wales and gave up that position to become Governor-General. So he was an important person in his own right. He knew senior judges around the country. He knew the people in the High Court. He was friends with them. He was not a person to be messed with. And Whitlam messed with him. And Kerr stood his ground against what Whitlam wanted. But there are many factors in the dismissal. Not only the fact of the position of Kerr. Whitlam himself had become very arrogant. Fraser had always been arrogant. Don't forget, Fraser brought Sir John Gorton down and caused Gorton to resign by casting a vote against himself. If the Gorton government had faced the 72 election, it might have won because Gorton was popular, and Whitlam would have gone into the wilderness, possibly. We just don't know. But Fraser caused a lot of problems. Fraser was warned by a senior opposition cabinet minister that if he pursued with the blocking of supply to force an election which would lead to other consequences, then that would severely damage the Constitution. And that is what happened, because without the dismissal, we would not be facing a republic today, because the only reason why a republic is alive in this country as such is because it is Labour Party policy to push a republic. In New Zealand, of course, there are Republican groups, but it's not a big issue. And there are members of all parties who are monarchists. In the United Kingdom, there are members of all parties who are monarchists. In Australia, there are a lot of Labour people who are monarchists, but they cannot say so. They cannot stand up and declare their feelings because they would lose pre-selection or be otherwise punished. And that is what 1975 and what Fraser and Whitlam are responsible for.
What's it?
And no insider trading on what went down in the palace?
My lips are sealed.
His lips are sealed. It's fantastic. Question here from Sam McMahon, another of our national councillors who's come up from Victoria. Great question, Sam. We've actually canvassed this, so I will throw it to Neville. Back to the Catamata. There is an adverse High Court decision regarding the Common Informer law, and I think that's the 1975 legislation that Sam's referring to. Do you think the current High Court could be persuaded to overturn it? And just in simple terms, what is this sort of getting at for the audience today?
I can't say I'm familiar with the case, so I wouldn't want to speculate. But the thing is, with the High Court, as has been said many times, it's not a question of following precedent, but in ultimately doing what is right. So, in general principle, the answer is that that it's possible for the High Court, given the right facts and given the right argument, could overturn any previous case.
Right. The Common Informers legislation allows you to take a matter before the High Court if you believe a parliamentarian is... No, that's okay.
Yeah,
that's okay.
No answer.
I don't know what the adverse case is either.
No.
But it allows you to take a matter before the High Court if you believe that the person who has been elected is actually incapable of sitting in the Parliament. Now, it's a bit trickier in our circumstances because the phrase incapable of being chosen or of sitting appears in certain sections of the Constitution, section 44 being notable. And you might remember back in 2017, 2018, people like Barnaby Joyce, Scott Ludlam, Larissa Waters, all these people were hit with section 44 concerns that they're actually ineligible to sit in Parliament because they were dual citizens. The section says they're incapable of being chosen. The wording in section 42 only says shall make and subscribe before taking their seat. And it's actually this before taking their seat that is vague and opens up the matter to so much speculation as to how do you deal with it? Do you take it before the High Court? Is it purely a parliamentary matter? Does the Speaker get involved? Is it a political matter? Is there something for the opposition? So there's so many angles to consider. It really is uncharted territory. I just go back to what Philip Fish said. We as public men have sworn allegiance to the Crown. They just couldn't possibly fathom that someone like Bob Katter would do this. But enough of the Katter matter. Morgan, a question for you from Anonymous. Have Australians since World War II had it so good until now, in brackets, that we have taken the Crown, rule of law, trial by jury, which came up earlier today, our institutions and so on for granted?
Yeah, I mean, I don't know if it's a post-war thing or maybe it's just always been a kind of complacency. But a lot of these great traditions are traditions that we've inherited. Unlike some other countries that had to fight for them, it was really handed to us on a platter, and it was our responsibility to cherish them and to carry them forward. Neville actually made a good point about how political leaders at one time used to be men of learning and men of the classics and integrity and ethics and men of character, and they knew all these lessons. They knew the traditions, and they knew their importance. And one of the great tragedies, and maybe it is a post-war issue, is we don't get those same kind of... Our elites are not of the same calibre as they once used to be, and they don't know those lessons, and they've allowed the traditions to be replaced, and in some cases replaced them themselves, because they think they've got, their new ideas are always better. This is where we are now. So it's call it the long march through the institutions, call it whatever you want, but I think that tells the part of the story.
A couple more questions coming in. I really like this. This is great. First of all, Matthew Sates jumped in and said the adverse case in the Common Informers Act is Ali and Gillespie, and Lou O'Brien will know David Gillespie in question there. That was, I believe, it's coming back to me now, he had some port asset or something, or a business, and there was a matter there that he hadn't disclosed, or something like that. So we're looking at all options there, and the legislation is one, but probably in our case, maybe not the one that I think will yield the result we want, which is for Katter to swear the oath. That really is the objective. Anonymous says, now here we go, this is a bit terse, this one, but I think it's worth addressing. There are a lot of Liberal politicians in the room. It would be only fair to give them an opportunity to explain their party's inaction on the Katter matter. Well, I'll answer this one as a Liberal Party member. Somehow I'm still a party member. I'm holding on to my membership. Look, first of all, no one from the House of Representatives in the Liberal Party here, where the LNP is represented, but we'll give Lou O'Brien a free pass because he probably didn't even hear Katter sitting where he is in the Parliament. We sort of have some background on this. Really, there were Liberal politicians who wanted to do something, and the leader got in the way. The leader, Susan Ley, also happens to be a member of the Australian Republic movement, or at least in the past has appeared in their adverts. Ted O'Brien is a former chairman of the Australian Republic movement. This is all public record. I've actually written about this in Sky. And, it's a shame because there were Liberal Party people there who wanted to do the right thing. I won't name them, but they're involved with us. And they were confused and affronted at the time when the incident took place. So as all things go, Philip's talking about the authoritarianism of the Labor Party. Members have ideas, but they're totally subordinate to the national platform of the Labor Party. It's becoming a bit the same in the Liberal Party, and I actually always think that the strength of the Liberal Party has been that it can disagree and disagree well. And I've thought about it over time. What Julian Leeser did during The Voice was actually a highly commendable thing to do, because whether he thought his opinion was correct or not, he believed strongly that the right thing for him to do, honouring collective responsibility, which is a cabinet responsibility, was to step down, sacrifice his career potentially because he believed in an idea. That's actually commendable. The inverse of that is not commendable. The inverse is, well, you've all got to, cabinet responsibility is one thing, but this idea that we've all got to be quiet and not espouse our beliefs, which may be beliefs that our constituents want us to espouse, that's probably not a good thing. We just monitor that situation, but it's a good question worth asking, I think. Okay, I'll throw to Neville on this. Any thoughts on the current GG's statements, good lead into the GG, which we'll finish out with, about how she would have acted if she had been in office in November 1975? You know what she said, I presume.
I do.
Yes.
Well, I think one has to be respectful of the office of Governor-General, but the way that certain designates fill the office leaves a lot to be desired, and I don't think it is possible for any Governor-General to generally say, I would have acted this way, given that they have taken an oath of loyalty and to uphold the Constitution in order to occupy the elevated office that they do, and to somehow ring bark or to ring fence one of the obligations that would be cast upon you, namely that of umpire, in a political impasse is just well, she said it, but can it really be the case that she knows what she would have done? If she's genuine in that, she's not fit for office because she's making a party political statement. In other words, I would have been loyal to the government that appointed me and never do it. If she's saying, look, weighing all of the ins and outs of the position, I think I could have approached it a different way, then that's less subject of criticism, but you'd have to articulate exactly what alternative you would have. And so I think an unqualified statement like that is inappropriate for a Governor-General to make, and is very, very disappointing, deeply disappointing.
Just if you can, Philip, and then I'll throw to Morgan on a couple of matters. What is really the problem with the Governor-General that we have? We've remarked that it is so on the nose for monarchists to be criticising the Crown's vice-regal representative, but if you could just succinctly package up, what is the danger that we are facing here?
The first thing that is wrong is that Sam Mostyn is a Republican and was active in pushing a republic. And therefore, how can she have any sort of integrity to accept a position as the representative of the King, which is what the Governor-General is? To be a representative of someone, you have to believe in them. To do a job, you have to believe in it. She obviously didn't when she took on the position. She wants to change things. She's going to the public and having podcasts and interviews. It's like no other Governor-General has ever done. And she's making mistakes. She's saying things that are wrong or can be misinterpreted. And it's throwing a confusion into the minds of the people that know and are seeing these things. Fortunately, the majority of people don't care what the Governor-General says, which would probably upset Sam Mostyn. But nevertheless, this is something that should not happen. And even though it went against the grain, we protested against this on two main matters. One, her inaccurate comments on different things, and she has written a personal letter that really didn't say anything. She also commended the Monarchist League for its position and so on like that. And most complainers would go away feeling very chuffed that they got a personal letter. She also indicated that about meeting with me to discuss the matters, which no date for a meeting has been asked for. The second matter was a protest that she had given royal patronage or vice-regal patronage to Equality Australia, which is an advocacy and a lobbyist group. They are pursuing changes in laws which will come before the Governor-General for royal assent. A Governor-General has to be very careful what he or she gives patronage to, because she cannot engage herself in anything that is political. An advocacy and a lobbyist group is political. Now, the Australian Monarchist League is an advocacy and a lobbyist group in many ways. We would never seek royal patronage because we know that is wrong. The king must be above politics, and so must his representative. That is a part of our system. Politics are dealt with by the Prime Minister and the elected government. The Governor-General's job is to make sure that the Constitution is maintained, not be involved in politics. And that is why...
Before the courts. Or before the courts.
Or before the courts. That is why we are protesting against the actions of this Governor-General.
It's funny that you bring up the courts, Neville, because we actually have a question here from the audience. I'll throw it to Morgan first, and then Neville, you might have a view on this as well. Bridie earlier in the day was very neutral in what she said, so as not to impugn the bar, but Neville, I don't think we'll get such reserve from you, shall we?
We're under no such restrictions.
No such restrictions. So the question is, where did it go? Here we go. Do you believe courts are increasingly interpreting constitutional conventions in ways that undermine the Crown's reserve powers or symbolic authority? Morgan Beck.
Ooh. Geez, I'm sure they are, but I can't think of a particular case. So maybe if I can handball it to Neville, and I'll ponder for a moment.
Yes.
Right. The courts really are called upon to adjudicate in this jurisdiction under a written constitution on reserve powers. The Whitlam case never went to court, and the matters that go before the courts really are ministerial discretions, and so it's a question of administrative law. And the way in which administrative law has developed, the High Court in particular has been very diligent, in my view, in trying to get the right doctrine. So there have been a few occasions, the TO case is an example, where the court has said in relation to immigration that interpreting the privative clauses in a particular way needs to be reviewed. We're going to get it right this time, and they tend to do that. I find it very hard to impugn the conduct of judicial officers generally. If a judicial officer makes a mistake at a lower or medium tier court, then the criticism is twofold. Either there can be academic articles written about it, in which case lots of arguments can be brought to bear, or in the individual case, to take the matter on appeal. And I have found generally that appellate courts are fairly cognizant of their duties to review the facts according to the rules that are laid down for determining the outcome of an appeal, whether the appeal is an appeal of law, whether it's an appeal of fact and law, whether it's an appeal of rehearing. And once they get the right characterisation, they tend to adopt a correct approach. Doesn't mean you're always happy with the outcome. and doesn't mean they always get it absolutely right. But to try and identify some sort of trend in that regard, I think first of all, it's a little bit like the French Revolution and its consequences. It's probably a little bit early to tell. But in terms of the royal prerogative, in direct answer to the question, I don't think there's a volume of precedent that could actually identify any precedent at all.
Yes, thank you, Neville. And having had a moment to reflect on it, I think the question was about constitutional conventions and symbols, is that right? Yeah, well, I mean, the difficulty is that those form part of the unwritten constitution, which is not quite within the jurisdiction of the High Court, which is to interpret the written constitution. Actually, it's Parliament and the Executive which is responsible for how they exercise and how they comply with the unwritten constitution, the constitutional conventions and all that. And so actually the actual culprits ultimately are Parliament and the Executive.
Funny questions come through on the auction pamphlet. This Christmas there's something for everybody in His Majesty's loyal auction is in quotation marks. Whom is the quotation from? The answer is me. And we are going to proceed to the auction very shortly. So I think I'll just round out State of the Constitution for this year, and it's the third iteration of what I hope you can see is a really valuable exercise to undertake. In really simple terms, as briefly as you can, are you encouraged by the potential future of the Constitution, or do you fear for it? We'll start with Morgan.
I'm encouraged because there's organisations like the Australian Monarchist League are growing and we're having impact. I mean, Philip's spoken about the actions that the organisation's taken to respond to the Qatar affair. I mean, you know, a great deal of the strength of the Republicans is in the fact that they do a lot of things without much notice being taken, and they operate in the shadows. And organisations like the AML shine a light on what was previously dark. So I commend the AML, and you know, I'm glad to tell you that it gives me great hope.
The Constitution, I think, will remain relatively unchanged for one reason, and that is, unlike most other constitutions established in what were British lands, and Australia was a colony of Britain, or the 6 states were, our constitution vests change in the hands of the people. Most constitutions vest change in the hands of the Parliament. If the Australian Parliament had the power to change the Constitution, we would have been a republic during the Keating years. The United Kingdom Constitution, which is uncodified, there's no real written constitution other than bits and pieces, can be changed or updated by the Parliament. In most other places, it can be changed or updated by the Parliament. Ours is vested in the people, and change can only be effected by a referendum of those people, both by a nationwide majority and a majority in a majority of the 6 states. That is our salvation and our protection.
I'd echo those sentiments. about the protections we have within the Constitution itself. I think that the founding fathers of our nation were quite careful to make sure that we had a constitution that was very hard to amend. So we didn't have fashions coming through and causing waves of change that would mean that we'd have several iterations of a constitution in a very short time. So I think, like the American Constitution, which is also very hard to amend, we're fortunate to have one that, insofar as it is in writing, it is quite clear. I think the real danger, and where I do have some pessimism, is that Republicans, knowing that they are probably fighting a lost cause because of the reticence of the Australian people to make a constitutional change, and also the inability for them to propose a model that would be better than what we currently have, and there hasn't been one propounded as far as I'm aware so far. I think in utter dejection of their plight in that regard, they will have nibbles at various things. And we were talking about those before, like what monarchs appear on what currency, how things are described in buildings, just all those little things that they can change without anything other than either an executive decision or even just the decision of a public servant. So I think where I am pessimistic is in that regard for the small nibbles. I think while we have a government that is so antipathetic towards the monarchy, that they'll have their little goes here and there and make things different, none of which can't be reversed. The question will be whether we get a new government in due course that actually will reverse those things. One can only hope.
Ladies and gentlemen, would you please put your hands together for Dr. Neville Rocco, Philip Benwell and Morgan Baird. Thank you.